Hello, I'm John Buckert. After filing a patent application, entrepreneurs often ask, what happens now? This phase of the patent application process is called the prosecution phase. There are 5 typical steps that occur in the prosecution phase. The first step that typically occurs is to receive an office action. After filing, the patent application will go into a queue at the USPTO and will be assigned to a patent examiner. The patent application will typically be formally examined about 1 to 1.5 years after the filing date. The patent examiner will perform their own patent search to identify the closest patents that they can find. Therefore, in a majority of the applications, the patent examiner will draft an office action document that initially rejects the claims of the application based on the closest patents. The USPTO will notify the patent attorney of the office action, who then notifies the inventor of the office action. The second step is to respond to the office action. Now, the office action will typically require a response document be filed within 3 months of the mailing date of the office action. The patent attorney can review the office action and prepare the response document that responds to the examiner's rejections. And in this response document, the claims are often amended such that the claims recite subject matter that is not taught by the patents cited by the patent examiner. Further, arguments are submitted to explain why the claim should be allowed over the cited patents, and the patent attorney will forward the response document to the inventor for the review and feedback. And after receiving the inventor's authorization to file the response, the patent attorney will do so and then forward the filed response to the inventor for the records. The third step is to receive a notice of allowance. Now, the notice of allowance indicates the pending claims are allowable over the cited patents. And the USPTO, or U.S. Patent and Trademark Office, will notify the patent attorney of the notice of allowance, who then notifies the inventor that they received the notice of allowance. The fourth step is to file an issue fee transmittal. The notice of allowance will require that an issue fee transmittal be filed within 3 months of the notice of allowance mailing date. The patent attorney can prepare and file the issue fee transmittal and pay the required USPTO fee. Further, the patent attorney will forward the filed documents to the inventor for the records. Now, the fifth step is ultimately the step you want to get, that's to receive an issued patent. And after the issue fee transmittal is filed and the USPTO issue fee is paid, the USPTO will typically issue a patent within 1 to 2 months. The USPTO will notify the patent attorney that the patent is issued, then the patent attorney will forward the issued patent to the inventor for the records. As one can see, there are several steps in the prosecution phase of a patent application. Also, you have a much higher probability of obtaining an issued patent if the prosecution phase is handled by an experienced patent attorney. If you have a product that you're interested in protecting, please contact us at 248-853-1422.